This meeting is being recorded. Good afternoon, everyone. Sorry if you just thought I was frozen on the screen. I was trying to make sure that the numbers were moving and I had opened up the webinar. Okay. So good afternoon. Good afternoon. Thank you for joining us. I'm going to give it a couple of seconds while a few more people come in, and then I'll come back. All right, looks like our numbers are setting. So just give me a couple of seconds and I am going to share my screen with you all. There we go. And of course, bring on my incredible co-host, Mr. Mike DiDonato. Good afternoon, Mike.
Good afternoon, Lauren. It's great to see you. Hello, everybody.
You as well. All right, let me jump into this intro. Mike, can you see my screen okay?
Sure can. We're good.
Okay. All right, so let me get it started. There we are. All right. Good afternoon, everyone. My name is Lauren Simpson. I am with the SBDC, or the Small Business Development Center. We're a national program with over 1,000 locations across the country, and we offer no-cost services to local small businesses. Now, our services are at no cost to you because your tax dollars have already taken care of our fees. For the Los Angeles network, which is a network that I actually represent. It includes the Los Angeles, Santa Barbara, and Ventura counties. We have several center locations, and you can find those on the map in front of you. You'll see we're as far out as Camarillo, Santa Clarita. We're over in Pasadena, Laverne, Los Angeles, Torrance, down to Long Beach. So if you are within the Los Angeles, Santa Barbara, and Ventura counties, you should be able to get in contact with one of our local service centers. And here's why you'll want to do so. We offer no-cost business advising. And so you're able to meet one-on-one with one of our business experts. And we'll have experts in the fields of taxes and finances, as well as marketing, licensing, and permitting. Honestly, you name it, we've got a topic and we have an expert to assist you. You might even be able to be lucky enough to sit with Mike DiDonato as well. And then we also offer virtual trainings, much like the comprehensive workshop you have joined today. So please be sure to get in contact with us today. We'd love to talk to you. You can call us at 866-588-7232 or go online to smallbizla.org/new client. If you've reached us outside of the LA area, please go to americassbdc.org/find your SBDC. Let me go ahead and stop my screen share. All right. So quick housekeeping, let's be sure we put all questions into the Q&A. Again, questions, please put those into the Q&A, and let's make sure they stay on topic. And then for the chat, we're gonna include any links or any info that Mike or GB, welcome GB, would like to share with you. So I see we already have a question. I'm in Orange County. If we wanted to talk to either of you on this topic, are we able to? So Mike, do you want to dive in?
Right. Well, I have a presentation ready to go for insurance, but is there a particular topic you wanted to cover, GB?
Yes, actually I came prepared. By the way, you guys can hear me today, huh? Unlike last week.
Good.
So I came prepared to talk about the entities and the liability and how we can close the entity.
Let's go ahead and do that then.
Perfect.
Okay. And as for someone in Orange County, it's best that they go to the Orange County SBDC group because they're better suited to help in that geographic area.
Okay, perfect. Absolutely. And then I saw that note about the chat. It is now available. I'm not sure why the settings keep changing, but you should be able to put items into the chat. Thank you, Shakura, for letting us know that. And I'll hand it off to you two gents. Thank you.
Excellent. How are you, Mike?
I'm doing well. And how was your week?
It was good. It's been productively good, so I'm happy. And it's good to be back here with working technology to present on a topic of limited liability. So can you see my screen?
Yes, we're good to go.
Excellent.
Let's do it.
The purpose of today's talk is to discuss what liability is limited when somebody starts an LLC and or a corporation. We're not going to talk about limited partnerships, limited liability partnerships, any of those entities. That is not the scope of this discussion. The scope is LLCs, corporations. A lot of us are told by TikTok, by YouTube, by a lot of professionals that, hey, get a corporation, get an LLC, you will limit your liability. And there's a lot of misconception out there about what liability is limited. And that is the scope on what is limited and what we can do as the agents of our entities to make sure that liability stays limited. So before I get started, Mike, since you have studied law and since you have helped a lot of people at SBDC, would you like to add any 2 cents before we delve into the presentation?
What I'd be saying, please keep in mind that there's always insurance available to you, which will provide an amount up to a certain threshold, up to a maximum level. So whether or not you form an LLC, you should have insurance. And you need to speak to an insurance broker, agent, or carrier to determine the appropriate amount of insurance and what type of insurance to carry.
And Mike, would you agree, even if somebody does get an entity, they should still get certain insurances? Because
Absolutely.
There's always somebody who can cast a doubt on your liability and or pierce a corporate veil to come after you personally.
Absolutely. You should always have insurance. What type of insurance will depend upon the industry, what type of product or service you're offering, what your revenue streams are, et cetera. But you should always have insurance.
Indeed.
Yes.
And I don't know if you ever experienced this. When I was much younger, I would say maybe 18 or 19, a young guy in college, I was surprised to learn that there's even an insurance product against accounts receivable. And the reason I bring it up is basically if somebody is willing to pay the premium, almost any risk can be insured. It just boils down to what is the probability of their risk and how much are you willing to pay the premium.
True. It's called trade credit insurance.
Exactly.
Let's go ahead, continue on with this presentation.
Perfect. So we all know limited liability, but what is limited liability? Basically, when one of us sets up an entity, especially an LLC or a corporation, we are setting up a separate taxpayer. It has its own name, it has its own identity, it has its own EIN number, and it is available and able to conduct business in its own name. It is that entity that we set up is liable for its own obligations, and those obligations could come in a variety of fashions. It could be employment obligations, so you hire somebody or the entity hires somebody, it has that person work, the entity owes that person a reasonable compensation. It has its own financial obligations to the lenders and the investors. It has its own fiduciary responsibilities and obligations and tax obligations. So we're basically saying, this is me, and I'm setting up a separate entity that will do business in its own name. And no agent, what the basic code in most states state is that no agent has a liability vicariously through the entity, because that is the whole idea, that we're separating your liability from the entity's liability. So if you are an owner, an employee, or a contractor, by default, certain liabilities, you are absolved from them because the entity that you have created is now liable for those liabilities and obligations. This is why the state of California and many other states levy a franchise tax, because the idea is a government entity is bestowing upon you an entity protection so that some of the obligations and responsibilities, you're no longer liable for them. So you're paying the franchise tax based upon the revenue, based upon the net income, to have that protection. The issue here, what becomes is, an entity is just a piece of paper. And just like currency, we have faith and trust that if we give somebody $5, they will give us something in exchange of the same or larger value. This is why inflation erodes the value of the dollar and causes issue. But in the same case here, it's a piece of paper. That piece of paper in itself cannot do anything. somebody has to act upon that piece of paper to carry out the obligations and responsibilities. And this is where we run into the issue is which liability is limited. So who may act on behalf of an entity? Well, if it's an LLC, it's a managing member. It could be a manager. It could be an authorized person. It could be an officer, such as a CEO, a CFO, a secretary. It could be employees. The expectation is that by default, a shareholder or a member of the LLC, the shareholder of the corporation or the member of the LLC is exempt from most liabilities. So think of it this way, and I used this example before. If you buy one stock or 1 million stocks in Tesla, your risk is only up to the amount of money you're putting into Tesla. Because if you buy Tesla for 100 and it goes up to 1,000 and you sell, you have that gain. But if you don't, and if Elon does something bad and the value of the share drops to $0 or $1, your obligation stops at the $100. If it goes up or down, that is your risk exposure. Whatever Elon does, you're not responsible. But if you are an officer, let's say a CFO, and Elon does something that the CFO should be monitoring and should be aware of, or by any chance, let's say a manager or a VP at Tesla does something that is egregious, maybe a sexual harassment, maybe financial embezzlement, or it could be wrong tax filings, Elon could be held liable because, hey, you were the CEO of the company. You should have been looking out for that. You should have set up those parameters to protect the shareholders' value. And that liability may sometimes lie with the managing member. So this is where a lot of times people are under the impression that just because I set up an LLC, even if I do something wrong or something wrong happens in the entity, I'm not liable. If you are just a member, but not a managing member, your liability is much more limited than if you are a manager member of the entity. By the same token, if your friend starts a business and you take up 30% equity in that business, but you're just putting money in, your friend is running the business as a CEO, you have limited liability. Whatever he or she or they do, you cannot be held liable. And this is why the Secretary of State of California requires every corporation to file a statement of information every year and an LLC to file one every 2 years, because it's public record that everybody should know this corporation or LLC, who's managing it, who's running it, who's the CEO, who's the CFO, who are the directors of this corporation. All of this information is public record. So if anybody has any real or perceived injury, somebody has to be held liable. And just because somebody has an entity doesn't mean they're absolved from that liability. This is why some of you who may be a professional, maybe you're an architect, maybe you're a lawyer, maybe you are a PA, by that I mean a physician assistant, or you are a dentist, or any of the licensed professional, you are required to have a professional corporation, not a general stock corporation. Because if you are an architect and you set up a corporation and you design some building somewhere and that building falls because you had a poor design, you cannot hide behind the corporate structure and say, limited liability, can't touch this. No, a professional corporation simply states that anything and everything that you are in the profession of, you have no liability protection to conduct and carry out that profession. This is why the state of California won't even allow a professional limited liability company. If you're a lawyer, you want to practice in New York, you can have a PLLC. California doesn't even allow that. This is how strict it is about even the managers and the members of an LLC won't even allow you to do so. So I have had clients who move from New York to here. They have to set up a new entity or do some sort of a conversion because their LLC cannot be transferred or moved here. Mike, anything you want to add to that before I go on, sir?
Just a little bit of terminology for those who might be confused. Member in this context means an owner of an LLC. That's
Correct.
different and distinct from shareholders who own financial interests in a corporation, which is different, distinct than partnerships, which that's a totally different structure. Don't be
Absolutely.
confused by the terminology. So when you fill out your paperwork to form an LLC, one of the questions is who's managing the business?
Mhm.
And you would elect, vast majority of the time, managing member. It could be manager managed or member managed.
Mhm.
And sometimes people make that mistake when they fill out the paperwork.
Indeed. And this is what I tell people, this is a public record. If you, even by mistake, claim that you are the manager member, and if something bad happens and you didn't intend to make that election, and somebody else should harbor that fiduciary or some other tort liability, because you made it public, somebody can use that document against you, because how will you prove, was that intention or was that a mistake? So this is why terminology, Mike, I'm glad you bring it up. Terminology is very important. And it's very easy to go to Secretary of State website and fill out a form to get an entity. But this is where Mike and I and other professionals at SBDC come in, because we can never tell you what to do, but we can advise you what are the pros and cons for any decision that you may be contemplating. And terminology is key. A lot of times people come to my office and say, hey, GB, I'm an S Corp. Great. What type? What do you mean? S Corp is just a tax election. It has nothing to do with a legal liability. So what is the underlying entity, LLC or a corporation or some other entity that is electing to be taxed as an S Corp? So terminology is key. I'm ESL, words have a lot of meaning. And this is where I encourage all of my clients as well to be very clear in the words we use, because sometimes an improper word usage with somebody can create an implied liability. Would you agree, Mike?
Absolutely. So know the terminology. Don't
And the
just
bigger
fill
the
out
target on
paperwork.
your back, the more careful you have to be. If you got nothing to lose, people may be more forgiving. But the target on your back is bigger, terminology is far more consequential.
Yes.
So when does a liability accrue? Well, there are different types of liabilities, many different types of liability, but mostly for the purposes of this discussion, it is either contract or tort. Contract is you are signing a contract with somebody, a lease agreement, a loan, maybe an employment contract. It could be independent contractor contract. It could be a variety of things. Basically, somebody shaking hands with somebody saying, we're going to do business together. Either I'm going to put in sweat equity or financial equity or intellectual equity, some sort of an equity or some sort of an effort, right? You're hiring somebody, they're not putting money in your business, they're putting in sweat equity. So somebody is putting something in your business and you're promising something in return. That's a contract. Could be explicit, could be implicit, could be written, could be oral. A contract is a contract. And then the other is tort. So tort is when something bad happens, right? Somebody does something that causes an injury to somebody. And as the third bullet point says, that injury could be physical, it could be emotional, it could be economical, it could be a variety of things. So breach by an actor. Who's an actor? Anybody who has any capacity to act within the permissions of an entity. So an actor could be an employee, a manager, it could be an independent contractor, maybe an insurance agent, anybody who is deemed to be allowed to do something in the name of the LLC or in the name of the corporation. Or it could be a third party. Most of my clients, I don't own anything with them. I have a contractual liability with them, but sometimes they authorize me to do certain things, maybe file their tax return, represent them in front of the IRS. Sometimes maybe run their payroll. I mean, there are a lot of things that even though I'm a third party, the entity authorizes me through the CEO or the managing member of the LLC to act in some capacity for the entity. So anytime anybody in the name of the entity does something, a liability is accrued. And that liability could be, like I said, contractual, tort, could be financial, could be economic. and somebody is putting their faith and trust, and if that faith and trust is in reality or perception breached, there is a liability. Anything you want to add to that, Mike?
No, you have it.
Thank you, sir.
It makes total sense. If someone doesn't know what a tort is, we need to be very clear, right? It's something
Yes.
that's outside of a contract, right?
Yes.
We cause some sort of harm to someone, some sort of damage.
Anything you want to add to that, Mike? Because tort is something that a lot of people don't realize. What they just think tort is something, criminal, which it could be, but it's not always criminal.
It's not. It could be negligence, by the way. It could be you use it unknowingly. You use a product that's defective, like you put up scaffolding. You should have inspected the scaffolding. You should have known that it might be a problem. You should have investigated the materials before you put it up, and it caused someone harm. That's a tort. Could be criminal if it's gross negligence, but certainly that would be a civil lawsuit. Go ahead.
Yeah. And would you agree that sometimes, even though for example, scaffolding, that brings up an example where one of my clients recently went through a huge settlement on the receiving end because somebody did mess up the scaffolding and it wasn't the person's job. The other party, they hired somebody, and my client was able to prove that that hiring process was not proper. The proper due diligence, proper background search, proper vetting was not done. So even though the opposing party was not in charge of that action, the third party they hired, they were negligent in hiring them. So a tort can even be created by extension because somebody says, you didn't do your job properly. You were either careless, you were negligent, or God forbid, grossly negligent. Each one would have a much different liability and damages stemming from that. Would you agree?
Yes, absolutely. And if it rises to the level of criminal negligence, then you may lose your protections against lawsuits. And then
this is why
people go after your personal assets.
Yeah. This is why California said, it was 2 years ago, that anybody who has 5 or more employees and owners count as employees in a Schedule C business, you may not be an employee, but in that law you are. If there's 5 or more, everybody has to have sexual harassment training. And if you're a manager or supervisor in any capacity, you must be trained every year, because if you're the owner, you hire a manager who hires an employee who's doing some sort of harassment, sexual, physical, emotional, whatever it may be, you can be held liable for hiring the manager, for hiring the employee, and creating a work environment that became toxic, and you did nothing about it. So this is where tort can be very serious. And if you are the manager, member, or just a manager of the LLC, or you are the shareholder CEO, or just a CEO of your corporation of one, you can be held liable personally for things that you do, especially under tort. Contract is much more protected. So I think, Mike, would you agree the majority of the liability protection extended to a shareholder or a member is mostly contract and very little in tort?
Yeah, that's true. Except when it comes to product liability issues. But yes, that's true.
Yes, indeed.
Or professional malpractice. Or professional
Correct.
malpractice.
Exactly.
Yeah.
So contract. A contract, by the way, the K stands for contract in here. If you are not a party to the contract and you are a manager of the LLC, or you are the CEO of a corporation, then you are not liable. Unless, of course, you co-sign for a contract or you do a personal guarantee. So, as the next bullet point says, being the activities of an agent to the contract doesn't create a liability. So, for example, you set up a corporation, you agree on a lease agreement, and you are the one showing up on behalf of the corporation, which you own 100%, to negotiate this lease agreement. Just because you are an agent doesn't create liability. You can do negotiations, you can pay rent, you can do all of that stuff. You can perform on that contract and not create any liability. However, if you co-signed for the lease agreement, or if you did a personal guarantee, you are liable. It's no different than you co-signing for your brother-in-law or your sister or your mother or your father. You have unlimited liability. If they don't pay, you got to pay 100%, not 50% or some fraction thereof. And this is why a new business trying to get a lease agreement more often than not will be asked to do a personal guarantee, because the landlord knows if the company doesn't pay a rent, he or she may have nothing to claim from. And this is what I think I've used the example before. Sometimes our clients, if the landlord is asking for 1 month of security deposit, they end up giving 3 months with the understanding that, hey, I'm not going to personally guarantee or co-sign for this lease agreement. This is only between you and my corporation or the LLC that I set up. Would you agree on that, Mike?
Yeah, that makes absolute sense. I would say this: be careful of what you sign. You see it over and over again. People don't read the contracts. They don't read the agreements. They don't know what they're signing.
Correct. Yeah, exactly. You're a new business. You go to the bank to get a loan or a credit card, and you think, oh, the credit card's under my business name.
Yeah.
There are some protection, but they will come after you, because as the officer, you are basically co-signing or personally guaranteeing the two different things for that credit card, and they can come after you, even though it may not even be reported to your credit report initially because it's a business card. But if you fail to pay, they will come after you. American Express is very draconian about that. So they're actually much, much, much stricter about that in many regards. So is Citibank. So depending upon which bank you're doing business with, they each have a different level of enforcement on that contract, depending upon, like Mike said, what are you signing in the contract? And this is why your operating agreements are important. I mean, if it's just you starting and running and managing the LLC or the corporation, you're wearing all the hats, is one thing. But if you are 2 or more people, you may want to have proper bylaws and operating agreement so that you are stipulating who has what liability. And it doesn't stop there. You have to share those bylaws or that operating agreement with the party you did contract with. This is why and here's a challenge. If they don't, let's say you're signing a lease and the landlord doesn't ask for your operating agreement or your bylaws, doesn't ask for a corporate or LLC resolution, it doesn't absolve them, because it's your responsibility to let everybody doing business with know, I'm a corporation or an LLC. This is the liability I'm taking on. This is what I'm authorized in my bylaws and my operating agreement to bind the corporation. This is my fiduciary duty or my performance duty under the contract, so that they know. If you never tell them, they may just assume they're doing business with you. And if they assume they're doing business with you, a court, when argued by a proper lawyer, can pierce a corporate veil and say, we never knew we were doing business with a corporation. We saw the INC, but you never acted like an INC or an LLC. Your actions speak louder than your words.
I have spoken to many clients who have formed LLCs because it's relatively easy to do. It's filling out a piece of paper. They don't even charge now to fill out the piece of paper.
Yeah.
And they either don't have an operating agreement, or they went to somebody like LegalZoom and they never read it. Or they set up a corporation, never read the shareholder agreement. And now something has happened and they have no idea what they're responsible for. Go to a professional first before you do these things. Understand what you're setting up.
Absolutely. And also see them periodically, because things change. Things that you could say and do just 5 years ago, you can no longer say or do. By the same token, laws, interpretation of the law, application of the law, and the code can change dramatically from 1 year to the next. So this is why it's not one and done. You need to review these documents periodically to still make sure you're performing on that contract properly. If you did co-sign for something 5 years ago, maybe your business is bigger now. You have built a strong balance sheet. Maybe you want a novation or an amendment to the contract so that you can say, hey, remember I took this liability 5 years ago? Now we're too big to fail within my industry, within the scope of whatever somebody signed. I want to be removed from personal liability. So it's okay. You know, somebody may have co-signed for you when you got your first car or your first home or your student loan, but now that you're doing well, would you ask them to co-sign again? No, you've grown up. As your business grows up, amend and change those contracts and those liabilities that you may have taken previously. And that may cost you time and money, but that's okay. It will save you a lot of heartache.
Yes.
Because here's a challenge. If everything's going well, nobody cares. When everybody's making money, all is forgiven. It's when things go wrong that finger pointing begins. And you're trying to protect yourself from this finger pointing. And very few people take personal responsibility. So if you have taken on that responsibility in the past, or you may want to do it now, be careful and relinquish that responsibility whenever appropriate.
Right.
Tort. So as Mike said earlier, tort is, you may have much more liability under tort because it's a wrongful act leading to civil or sometimes criminal legal liability. For example, car accident. So in that car accident, let's say you claim that your business owns a certain car. Maybe you bought a nice truck and you wanted to take the bonus depreciation, lower your tax bill. You pledged that truck to your corporation or the LLC, and you say, hey, I bought this truck for $50,000. My taxable income was 50, and my accountant was able to make it 0. So now that truck is now pledged to your entity. Well, that's a tax move. Legally, what happened? Is a truck still registered to you? Is a truck still insured by you? Does your insurance company know that you are using this truck that you told them that you bought for personal purposes? You've been driving around to carry out your business or your trade or your profession? All of these, so God forbid there's a car accident, all of these questions will be asked. They don't care. You took a $50,000 deduction on a truck that you gave a $5,000 down payment on. They will say, who owns this thing? Who insures this thing? Was it operated within the proper allocations and the proper responsibilities of somebody? You know, it's one thing you drive that truck to pick up your kids from school, AAA, farmers, anybody else may cover, something bad happens. And remember, it's not just something bad happens to you. Sometimes my kid says, Dad, I don't want to wear a car seat. Why don't you drive carefully and I'll take the car seat off? I tell him, son, I can do my best to drive carefully. God forbid somebody else makes a poor decision voluntarily or involuntarily, and they hit us, you will get hurt just the same, no matter how carefully I'm driving. So remember, sometimes bad things happen to good people. You may be doing everything right, but you may be creating a tort liability because somebody else does something wrong. And depending upon who owns that asset, who owns the business, who's running it, who said what, who committed to what, who was, okay, all of these things will be questioned. Your actions and your motives will be questioned to figure out, is this liability limited to you, or is this liability fully on you and you're liable no matter what, whether you have an LLC or a corporation? Because most claims lead to either physical or economic harm, and both of those are treated differently. Would you agree, Mike? Somebody claims
Yes.
a breach of contract or a civil case is very different than a criminal case.
Right. There's all different, yes, absolutely true. There's all different types of remedies for breaches of contract and different types of damages, which we can't go into here. That'd be for another time.
Exactly. Exactly.
But yeah,
So,
but more importantly, you have to be able to define economic loss.
Exactly. Exactly.
Okay.
Somebody's got to pay. Somebody's claiming I am hurt. This is why, again, we got the EIDL, right? Economic injury disaster loan. That, hey, everybody got hurt by this COVID-19. Everybody gets $1,000 an employee. And if you have your cost of goods sold and your tax returns, everybody get money because there's an economic injury. PPP was a little different, right? Because PPP was forgiven. So the rules were very different because EIDL, you're expected to pay it back. PPP will be forgiven. So there were different rules and different hoops you had to jump through. So what is economic loss? It could be loss of profit. It could be diminution in value, lost opportunity, monetary losses. You know, we all know we shouldn't value money too much, but we do value money enough. So if somebody claims, your employee says, you know what, I have a lost opportunity that because of what you did, I could have had a promotion, but you discriminated and I never got that promotion, I never got that raise, I have a lost opportunity or a monetary loss. You may say, hey, I hired you to do this, you didn't do this, I didn't fulfill my contract, so I lost a profit. Economic harm happens all day, every day. Now, economic loss doesn't always translate to tort. It could be contract. Why? Because unless you have a professional service. So if I mess up your tax returns, or if you hire a lawyer and they don't represent you properly, or a doctor causes you harm or death, malpractice, that's financial tort. It could be different. Of course, fraud and negligent misrepresentation can also cause economic loss, and that's a total different liability. So this is where you can get an idea who's claiming what injury, done by whom, for what purpose, and to what scope. But that's financial harm. Physical harm is totally different. And usually in a physical harm, if you do that physical harm to somebody, let's say you're the, I don't know, manager, member, shareholder of your entity, and you punch somebody for whatever reason, no matter how justified it was, you may be held liable, most likely always. It may also lead to emotional harm, right? Not all injuries are visible, such as PTSD. So somebody can claim that because of the toxic work environment that you as a manager created, they have PTSD. And usually this type of liability is not limited just because you have an entity. So this is why proper insurances, proper procedures, proper HR rules, proper, whatever that proper is, you're supposed to take care of it. You cannot hide behind an entity. Now, why do I talk about all of this?
JB,
Sorry, go ahead.
JB,
Yes, sir.
If your thought is that I have insurance and that'll protect me to the nth degree, that's the wrong thought. Because
Yes.
insurance companies have their own rules in place. And if you don't behave appropriately, conduct yourself appropriately, have your employees conduct themselves appropriately, if you don't have the right rules in place, policies, and procedures, then the insurance company may deny your claim.
Mhm.
Okay. And then you may be facing a courtroom of lawyers, and you still may lose your protections against liability, personal liability. So keep that in mind. Insurance companies have their own rules, policies, and procedures that you must follow. Okay.
This is why they get a bad rep sometimes, because there are, just like any other business out there, just like any family member out there are people with scruples and there are unscrupulous people. So there are some bad insurance companies out there, no doubt about it, bad attorney, bad family members, bad whatever. But an insurance company more often than not will deny a claim that they label as act of God. They're also under no obligation in aiding and abetting a crime. So if you file a claim because, hey, you created a toxic work environment, somebody is suing for sexual harassment or emotional harassment or physical harassment, they're not going to pay the claim. Hey, you should have known better. I have a client who is almost bankrupt because he had a huge fire in his office building and he lost everything. And he's actually a small manufacturing plant because the insurance company ruled that you didn't properly maintain the electrical. You should have had an electrician check on this periodically. And the last inspection was when you bought the property 12 years ago. You have no record of ever inspecting this since then. Claim denied. The guy he didn't do arson. It's a valid. Nobody's saying anything. They're saying you didn't properly maintain. This is why, if you buy a brand new car, it comes with warranty, bumper to bumper. You do any modifications to the car, that liability is null and void. So keep all. So Mike, I'm glad you bring it up. Just because you have insurance doesn't mean you will have claim paid on that injury to yourself or somebody else. So thank you for bringing that up, Mike.
Sure, that leads to a question from Alexis. She sells less than $100,000. She's a sole proprietor, which means she doesn't have an entity, right? She has liability insurance for her warehouse and workers' comp. Do those cover in times of an accident? It depends. What was the nature of the accident? How did it occur? Right? The facts count in answering those questions, which is why you would have to seek legal representation. Go ahead, GB.
Yeah, no, actually, one thing I see a lot of times people overlook is, a lot of people like to hire independent contractors. I just give you the money, not on my W-2. But if that independent contractor causes any harm to anybody in your business, your insurance company want to have indemnification, they will say, okay, great, who did this harm? Joe? Okay, Joe is what, independent contractor? Great. Did you check for Joe's policy? We need a copy. Well, I don't know if Joe has insurance or not. Oh, then you allowed somebody to operate your business without proper insurance. That's a big problem. It's like letting somebody drive, or it's like driving somebody's car without insurance. It can cause issues. So even if you hire independent contractors, so this is where if you have an entity, independent contractors, and you're right, if you have a liability insurance, what does that cover? What does it not cover? What are the exclusions? It's very important to read that policy very carefully. And where the dollar limit, California said if you drive a car, you should have $15,000 bodily injury insurance, I think, or $16,000, and I think $5,000 of property damage. Well, that's great. You get that check in the box. You have auto insurance. The cops cannot give you a ticket or impound your car, but you have $5,000 of property damage. You hit somebody's brand new Tesla, $50,000. The insurance company will only pay $5,000. The other $45,000 on the brand new Tesla is your responsibility. God forbid you hit somebody's Lamborghini or Rolls Royce or Ferrari, which are very common on 405 and 110 freeways. So just having enough insurance means enough for what? Would you agree, Mike?
Yes. Darcy, and please put your questions in the Q&A. She asked, how does having an LLC help a small business then? Why should we keep it? You should keep it because if you follow the rules, if you act appropriately, act as a prudent business person, then you will have protections against lawsuits. Okay, it's not 100% protection, but it's certainly much greater protection than if you are a sole proprietor, because then you're subject to unlimited personal liability.
And what I'll add to that, there are also tax benefits. So right now I'm talking about legal benefits, and because the legal benefits also then lead to the tax consequences, because a lot of times people start entities because a proper entity, properly managed, properly maintained, properly pruned periodically, can have tax benefits on an ongoing basis. But the other reason why I brought up this whole topic and I laid the foundation is sometimes people have to close the entity because then they think, oh shoot, this is not what I thought it was going to be. And the amount of money I'm paying to the franchise tax and the tax preparation and the tax planning, this is not worth it. So sometimes they want to close the entity. And sometimes people think I can just close it and we're done. It's not so easy because even closing the entity, because you got the tax benefits, can have ramifications. So I'm going to talk about that in the next maybe 10 minutes or so, but keep in mind, there are legal benefits. Like Mike said, when you properly set up an entity and properly document, properly run, properly manage an entity, but there are also tax benefits. But on the flip side, what are the tax consequences when not properly managing an entity? Well, if you want to close an entity, there are different types of closures you can entertain. There's the administrative dissolution, which means if you started an LLC 12 months ago or less, and you don't use it, or you don't see any benefit to it, or you think it's too much, whatever it is, if it's less than 12 months, you can tell the agency, Secretary of State, that I don't need this. Depending upon you did business or not, you may not have any LLC minimum tax. You may not even have any franchise tax, but if you have an LLC, you still have to pay the LLC fee, which is based upon your revenue. And if you have any income tax liability, you still have to pay that. But basically, you don't have to pay the franchise tax. So why is that important? Because the minimum franchise tax is $800. But if you only had, I don't know, $1,000 worth of net income, and you're elected to be an S corp, your tax liability is only $150. So you don't have to pay the $800 franchise tax if you do so within the first 12 months. Okay, let's see.
No, GB, if you have an S corp election, it's 1.5% of net income or $800, whichever is greater.
Well, the first year there's an exception, is what I'm saying.
Yeah, first year there's an exception.
Yeah. So this is where, if you started last year, let's say you started an LLC in, I don't know, November of 2021, and the franchise tax was due April of this year for tax year 2022, but you are electing that within the 12 months you're closing. So if you made any money, you owe the 1.5%, but you don't owe the 800 because you're closing within your 12 months. So in almost every case, a franchise tax board will waive the $800 franchise tax minimum requirement, and they will only expect you to pay the income tax and or the franchise tax of 1.5%. That's what I meant over there. The minimum tax abatement is available, if that makes sense.
Yes.
Okay, perfect. So that's the administrative dissolution. That was within 12 months, and you're telling them, I got this, I don't need this, I don't want this, I want out. I don't have a legal or the tax benefit. But if it's been more than 12 months, then you can choose to do a voluntary dissolution. There's a whole process to it. I'm not going to go into that, but basically you have to get the franchise tax board clearance, and you have to file the proper form for the Secretary of State, basically attesting that this company has wound up operations. It has no longer any asset. It has no liabilities. We got the FTB, which is a franchise tax board clearance. The entity has paid any and all franchise and income taxes that may have been due. Because if, again, what people say, what are the income taxes? If you chose to be a corporation and you chose to be a C Corp, it has its own income tax liability beyond the franchise tax. So that's what I mean over here. And if there's any penalties, you can get certain penalties waived by the FTB because they don't want to add insult to injury. You're closing up shop. So when you do so properly, they're willing to work with you to abate maybe any estimated tax penalty or any demand penalty because you didn't file a tax return in time. There's a demand penalty. They're demanding a tax return. You're closing up. They say, okay, as long as you pay the taxes due, we call it quits, go your way. We don't want to bother you anymore. So that's a voluntary dissolution. It can be a month, like 6 to 9 month long process, but you want to do so before you can walk away from your responsibility. And then, of course, there is the involuntary dissolution. This is where you're not choosing to dissolve the entity is being dissolved for you by the Secretary of State. So since 2020, the new policy is if your entity stays suspended by the franchise tax board or the SOS for a continuous 60 months, you are subject to involuntary dissolution. So this is where, and now that's assuming you have no outstanding tax liabilities. If FTB is sending you notices that you owe money, you will not be dissolved involuntarily. But assuming it's just an inactive entity, you never filed a statement of information, you never filed a tax return, you are suspended, they will give you 60 days. There will be a public posting and there will be notices sent to your last known address for the entity. If there's no response, no nothing, the entity will be closed for you. You want to avoid that because there can be some unintended consequences. But if necessary, I always encourage my clients to do the voluntary dissolution so that you can get your penalties abated and you can move on freely from any liabilities for income and franchise taxes. Because there are cases where if you abandon your entity, there can be tax consequences because the limited liability may or may not be extended to you just because you have an LLC or a corporation. So what do I mean by that? If you abandon an entity and you still stay in business, or maybe you got a corporation and it's too expensive, too many formalities, or you got an LLC, too expensive, too many, whatever the case may be, you got an entity and you say, you know what, I don't need this. I'm gonna just continue doing business as a DBA or as an independent contractor. And you continue to be in the line of business that you had supposedly incorporated. Well, in the eyes of the Franchise Tax Board and the IRS, you took a distribution from the business involuntarily, which means it creates a tax liability for you. And you may all, because you're continuing in that vein without closing the entity, you are now personally liable for any and all corporate and or LLC, state and federal income taxes, because you basically relinquished your corporate liability protection and you continued in the business. So this is where if you are a plumber, if you are an accountant, if you are whatever, and you continue in the profession that you had incorporated or created an LLC, do a proper dissolution. Otherwise, you could be held liable for the entity's taxes. On the flip side, maybe you are out of business. And so this is where you still want to do a voluntary dissolution because you want to, on the taxes, you want to mark, this is my final tax return. And before you just walk away from a defunct or an abandoned business, because the tax agencies want to know what were the accounts receivable for the entity and who collected them or who wrote them off, depending upon cash or accrual. Was there any inventory in the business? And that were there any equipment, tools? Maybe you pledged your car. There are tax consequences. You took a big tax deduction. There are tax consequences. Who has a liability for that? What about the client list? A client list is an asset. You could, people do this, right? This is why we get free stuff online. We get free Hulu or whatever because they're collecting our data and they're selling that data. A client list is a data that can be sold to somebody. That is considered an asset in the eyes of the tax agencies. Who's responsible for that? What did you do with that? What about the intellectual property? Were there any patents, any trademarks? The idea is this: if you declared on a statement of information to the Secretary of State that you are the CEO of this corporation that you started, or you were the managing member of this LLC, and now you're out of business, before you just walk away so that liabilities can stay and die with the entity, you have to file those tax returns, you have to file the final SOI, and you have to do the dissolution. So you're saying this entity, which was running this business, is defunct, there's nothing to collect here, we're out of business, the liabilities rest with the entity, don't come after me. But if you don't do that, if you just abandon it because you're out of business, those liabilities can follow you because as the officer or the managing member of the LLC, you did not properly close up shop. Does that make sense, Mike? Anything you want to add to that, sir?
No, it's perfect. But as always, come talk to us, talk to a professional before you take any actions. The tax consequences might be significant.
And again, if there's any payroll tax liabilities, somebody has to take personal responsibility, and those are extremely, if not impossible, to walk away from. Same thing with sales and use tax. So we didn't even touch those things because the CDTFA and the other Department of Revenues across the country and EDD, along with the IRS, if you had employees and you misclassify them, that's a liability you cannot relinquish because somebody has to take a personal guarantee anytime you get a sales and use tax permit or you get a payroll tax account with the EDD because you're hiring employees. So, I mean, because this is EDD uses that system to collect on alimony, especially child support. So this is why sometimes you get notices, right? Somebody has a child support claim and they're not paying it. And now you are supposed to tell the state when you hire a new employee so that you could collect on that child support and pay the receiving party. So when it comes to those taxes, those are extremely hard to relinquish if you don't run the entity properly. So this is why I did this whole presentation. Limited liability has a very limited scope depending upon whom you're doing business with. Is it a contract liability? Is it a tax liability? Is it a tort liability? Don't think and don't let anybody ever convince you that just having an entity, you can do whatever you want. You can do whatever you want within this narrow scope. Everything else can still be assigned as a liability to you, especially if you are the manager member or you are the CEO and or the director of a said entity. Protect yourself is the point, the purpose of this presentation today. Protect yourself through proper planning, protect yourself through proper bylaws and proper corporate and LLC documents, protect yourself through proper insurance, protect yourself through proper advice, education, experience, the list goes on, because what you know today will change tomorrow, and what you knew 2 years ago has already changed. Anything you want to add to that, Mike?
No, please don't forget to keep your books clean too. It's not
That's
just
a whole different
about-
liability.
Yeah, but if you don't keep your books clean, if you come in funds, then you're subject to losing your protections against lawsuits.
Indeed.
Court of law.
I think, Mike, I was told by a very proper lawyer that financial commingling is one of the most common and easiest way for somebody to pierce
It
a
is.
corporate veil.
It is, absolutely is. And if you have questions about it, talk to people who are knowledgeable about how to keeping your books clean. Okay,
The point is not to scare you. The point is to empower you.
right. Exactly.
Cool.
I
hope this was fun.
It was great.
I enjoyed it.
Thank you. Thank you.
And I think
So
you're doing insurance. Is that what I heard?
Yeah, next week we're going to be talking about insurances. I don't know, I counted 10 to 15 insurance products that a business might consider. And you're right, some of them like you would never think about, like cargo insurance. So we think about cargo insurance, but it exists. Okay,
It does.
Freight insurance. So we received a request last week to talk about insurance. We'll go ahead and do that. Now, we're not insurance experts, but we can give you some information on insurance. Okay.
That's a good point, Mike. So thank you for doing that.
Sure. Thank you, everybody, for attending today. Appreciate it, Lauren. You're awesome. Hopefully we'll see everybody next week, and tell your friends. Bye now.
Take care, everyone. See you.